Please be seated. Our second case for this afternoon is Laurie Rennekamp and Nelson Rennekamp versus Issam Abdullah. I believe I pronounced that correctly. Is counsel ready to proceed?
We are, Your Honor.
Counsel, we have allowed 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
I'd like to reserve 3 minutes for rebuttal, if I may, Your Honor. May it please the Court, my name is Charles Bell. I'm here on behalf of the appellants in this matter. Just to correct the caption a little bit, Mr. Abdullah is one of the other potential plaintiffs and appellants in the case. The actual appeal is against Seahaven Phase 1 LLC. And I'd like to start the argument with the third issue we raised in our brief, and I do that because I think that is really where the dispute arose between the parties, and it really explains how we got to where we are. The trial court dismissed the claim that we had brought for rescission and damages under the false advertising provision in the Condominium Act, Section 718.506, with prejudice. There is no dispute by anybody that the complaint itself states a proper cause of action under that statute, but what the trial court held was that a single paragraph on the 12th page of a 20-page contract attached to the complaint expressly refuted the allegations of false advertising. And we believe when the trial court made that ruling, it erred as a matter of law. I want to make a few points about that. First, the threshold problem is that the trial court's ruling, if left to stand, would essentially eviscerate the statute. Section 506 is, in a sense, a statutory cause of action for a form of fraud. And Florida law has been clear for ever as far as I'm aware that a person cannot disclaim in writing a prior fraud. And again, it's important to keep in mind that this was not a disclaimer paragraph attached to the advertisements themselves. This was a part of the contract itself that was introduced into the deal much later on. This is not like a situation where you see on TV where the person makes the advertisement and then you hear the results may vary language at the very end. This is a situation where the advertisement said one thing and they argue at least that the contract says another. Now, it doesn't, but as a practical matter, it shouldn't matter. The disclaimer shouldn't, as a matter of law, be enough to defeat the claim. Even if you assume that the developer could disclaim the fraud, there are problems with the alleged disclaimer itself. The first
is the contract that was attached to the complaint that the trial court relied upon to basically say it refutes the allegation.
Sure.
Was that contract something that was approved by the condominium agency? I know a lot of things are, but is the contract something that they approve?
Your Honor, I don't know the answer to that question at all. Perhaps my opposing counsel might represent the developer, but I do not know the answer to that. I know the amendments themselves have to be approved. I'm not aware if the contract document is part of that process. And we don't have a problem with the contract. We just don't think it says what they say it says in that sense. If you look at it in context, and the contract provision is on page 106 of the record, there's nothing about that is conspicuous. And as the Court is aware, for a disclaimer to be approved to get somebody out of anything, much less fraud, it's got to be conspicuous. Where this disclaimer is not in bold, it's not all caps, it's not italics. It's on page 12 of a 20-page document. The heading doesn't say disclaimer. It doesn't say warning. Everything we've told you in advertising may not be true. What it simply says is development, the one word development. Contrast this with page 107 of the record when you see the warranty disclaimer that the developer put in for warranties of habitability and the like in all bold print. Alerts the reader to that because, again, this is designed for consumers, not designed for attorneys. Second, we need to look at the context under which this alleged disclaimer paragraph came into being. The trial court read this paragraph as saying basically that any representations and warranties we made about the other parts of the development, the amenities, the movie theater, or the ice cream parlor, the post office, the whatever, all those things, we may not even build at all. We have a right to do whatever we want to do. But if you look at the paragraph in development and you look at the issues before and after in the record, you'll see where that is buried. For example, page 105, right before this, under the words off-site improvements, the contract says it warns the construction of other parts of the town might cause inconvenience. Page 107, the very next page, it says the condominium is located within the town of Seahaven, which is open to the public and is expected to generate an unpredictable amount of vehicular, pedestrian, and other traffic. Page 108, the next page. The buyer acknowledges that the condominium is located within town of Seahaven and that current development plans for town of Seahaven contemplate a high-density pedestrian community with both commercial and residential uses. So in other words, they're arguing this one paragraph says we don't have to do any of this stuff, but the rest of the contract around it talks about all the development that's going to be taking place. It's going two different directions. But the biggest problem with this provision is that it simply doesn't say what they say it says. As the federal district court in the Gentry case held, to avoid a cause of action for false advertising under this statute, the language in the contract must, quote, expressly contradict, unquote, the allegations in the complaint. Now, what does expressly contradict mean? I think it's fair to say that it means look at what an average consumer would read, and if it takes someone time to diagram sentences in order to figure out what it means, it can't be expressly contradictory. If you look at the allegation, at the language on page 106 of the record, which we've quoted in full in our brief, it never mentions the amenities by name. It doesn't say movie theater, it doesn't say pool, it doesn't say ice cream parlor, it says units. It never mentions any representations that it was disclaiming. It just says we may or may not build all the units the way we said we were going to build the units. It doesn't say that the developer cannot do anything at all. It talks only about units. Now, the best way to look at this, I think, is to compare and contrast that language with the language used in the very same contract in the Beach Club disclaimer. Now, the Beach Club is also one of the things promised in the advertisements, but the developer has a specific special disclaimer for the Beach Club, and we put that in quotes in our reply brief. What the developer says on page 108 of the record, it says the Beach Club, quote, may be developed. There may be a beach club. Two different times in that paragraph it says, if the beach club is built. And then the kicker, the last sentence of that paragraph says, at this time, the developer does not guarantee that the beach club will be developed. Now, there's 2 points about this that I think are very critical. First, if the developer truly wanted to disclaim any representations or warranties in its advertising materials, it had a very good example of how to do it. It could have simply used the same express language in the Beach Club disclaimer, which even we agree is very clear and very unambiguous. The developer says, we may not do this. Didn't do that. But here's the real point about this. If the language that the trial court relied upon says what it said, there's no reason to have included this second disclaimer, because the Beach Club disclaimer would have been part of the overall disclaimer they're arguing. Why would you create a separate disclaimer just for the Beach Club if the paragraph the trial court relied upon already told the purchaser, we may not build the Beach Club? And to me, that is the critical issue in this particular cause of action. Does this one paragraph on page 12 disclaim everything? And when you compare that to what the Beach Club disclaimer says, we believe the answer is no. Otherwise, the Beach Club language would have been superfluous. I want to turn to the first issue on appeal. And the first two issues obviously relate together to the summary judgment entered by the trial court. And we think that the first issue, and to a large extent the second issue on appeal, simply come down to black letter summary judgment law. What happened in this case is my clients alleged in their complaint that they had timely rescinded the agreements, timely gave notice of rescission. Because we had alleged that in the complaint specifically, under the rules in Florida, the burden shifted directly to the developer to produce evidence that refutes that allegation conclusively. Okay?
And didn't they do that? I thought they brought in certified receipts showing that they sent these amendments or whatever to your clients, and your clients were saying, well, I thought there was an acknowledgement somewhere. The lawyer said, yeah, my client's got something, and your clients are saying, no, we didn't get anything. Isn't there a level of common sense here?
There is a level of common sense, but we're not at that level in this, under the facts of this record, Your Honor. First, on the attorney letter, what we point out in our reply brief, what the attorney says is many of my clients have received these documents. So the attorney, Mr. Beasley, did not say all of my clients have received these documents. So it's very clear that was not an omission. But what the totality of the record evidence produced 20 days in advance of the hearing by the developer, and the 20 days is really the key because they tried to correct this close to the hearing, which I think, I would hope they would agree now is improper. 20 days before the summary judgment hearing, they produced a cover letter, a single page cover letter that simply mentioned some disclosures. It did not attach the documents that were enclosed. The letter itself did not list specifically, here are the enclosures, A, B, C, D, E, F. It just said some things. So all we have is a cover letter with nothing more. We don't have any affidavit of mailing. We don't have any affidavit of anything like that. What we have for two of the appellants, for I believe make sure I got this correct, for the Moriartys, we have a signed postal receipt showing they received something. That's all we know. That's all they put in the record. They received something on that date, and there was a cover letter. Even if you assume they received the cover letter, that doesn't satisfy the statute because the cover letter doesn't show what was enclosed with it. For the Rennekamps, they didn't even show that. What they had is a Federal Express receipt showing that something was left at their doorstep. Not that it was signed for, that it was left at the front doorstep. And that also doesn't say what was left at the doorstep or if they actually received it. And
so whatever they received weighed half a pound.
Well, exactly. And again, I don't.
It's more than a cover letter, isn't it?
Well, I understand that, but we don't know what it was. And again, summary judgment burden, Your Honor. I recognize that, and that's a good issue for trial. That's the argument they're going to make at trial. But this is an issue of whether we should get to trial. And Dr. Hussain is really important. They didn't even introduce a receipt. All they did was introduce the mailing certificate without an affidavit as to what was enclosed in the mail. Then if you look at what the Dr. Hussain and the Rennekamps both introduced affidavits in the record, they didn't have to, but they both said we didn't get them. So, you know, even if you assume they did everything, even if they put in the record the actual mailing affidavit, the course and custom affidavit that is so often the case in these cases of mailing, which they didn't do, the Rennekamps and Dr. Hussain actually refuted that in their affidavit. So looking at the summary judgment burden in Florida, they didn't meet it to show this.
Counsel, you're saying assuming Ms. Haig's affidavit was timely filed, assuming it was timely filed, it was not sufficient in order for the trial court to grant the motion for summary judgment?
I don't even think the Haig affidavit, if it had been timely filed by itself, would be sufficient because it didn't say on this day we mailed this to everything, all the people. Here's the list of people we mailed it to. We mailed these specific documents. These documents were all received. The Haig affidavit was much more general. It was much more overall big picture than that. So even if it had been timely received, we don't think it conclusively establishes the fact. But at least it would be an affidavit to show something was mailed. And right now we're simply left with a single sheet of paper and a single receipt or lack thereof in the case of Dr. Hussain.
So on the one hand, you have an affidavit with certified return receipts. On the other hand, you have from the appellants their individual affidavits saying they didn't receive it. Therefore, we have a question of material fact regarding whether or not the appellants timely received the information in question.
Absolutely. We think there's an issue of fact about receipt. You know, again, all the evidence that the court is pondering, the common sense arguments and the weight of the package, all those things can come into evidence at the trial on this issue. But the case law in Florida is very clear that the mailing rule has to be invoked, has to be met with some sort of affirmative evidence that something was mailed to assume that something was received. And that wasn't done in this particular case. I'm into my rebuttal time. There obviously are issues of material changes to the contract that I will be happy to address. But we think the briefing on that issue explains that in quite detail, that materiality in Florida is an issue of fact.
And all those issues, whether one of those, at least one of those changes, whether it's material is still down at the trial court, isn't it?
Well, it's actually not anymore. It was at the time of the briefing. The second appeal from basically everybody else has been filed. We filed our initial brief a week or two ago. The second brief has not been filed yet. And it really does, the issues are identical with one exception. And the trial court did, in fact, rule against my clients on that last remaining issue. But that was done, you know, since this occurred. So. Thank you.
Counsel. Counsel, given that generally materiality regarding a change in an agreement is a question of fact to be determined by the trier of fact.
Yes.
Why wasn't materiality of the changes to the agreement, that is the amendments themselves, not a question to be determined by the trier of fact in this case?
If we, in termination with materiality, assuming this issue relates to amendments, there are three issues that have to be proved for the plaintiffs to prevail. One is material alteration or amendment. Two is that it affects the offering, and three, that there is an adverse effect on the plaintiff involved. But the summary judgment trial court judge determined that there was no triable issue of fact and law with regard to all three. They had to be proved conjunctively and together. And that's where we are here today. If I cannot convince this court that there's no triable issue, for example, as to adversity, adverse circumstances, or that there's no triable issue as to one of the 14 claims, then the issue of what you do with the other claims that were not proved to have no triable issue. The court, in looking at this, held extensive hearings on each one of the 13 issues. If you turn to the December 10th, 2008 order, and page 2, they listed those particular issues with regard to the cause of action for amendment. These are amendments, and the court ruled that all 13 of them were not, the burden was not carried, and that there was no need for a trial of fact on it. Of the 13, 4 of them were admitted at the hearing by counsel.
Of course, we don't get to the second issue if we affirm on the notice, the timeliness of the rescission, right?
Yes, that's correct.
How do you respond to counsel's argument on the two causes of action, two claims that were counts, I guess, that were dismissed on the grounds that the contract refuted them? Counsel argued that the scope of that disclaimer, he took issue with where it was placed and those sorts of things, but he also argued that the scope of that disclaimer doesn't subsume the things that they claim to have been misrepresented to them. What's your response to that?
The court relied heavily, as we do here, on the fourth amended complaint that was filed in November of 2007. And in that complaint, that there was attached the contract, and the contract was referred to in the fourth amended complaint as being the model contract, the standard, and it was one that was signed and admitted was signed by everybody. And in that contract, where we stand is the extensive disclosure of all of the issues he calls disclaimers. One of the particular issues is he talked about the beach club, but the issue is that this condominium of some 280 units is on the north side of the Front Beach Road, and as a result it's across in the Gulf. And the developers wanted to make sure that they let the 280 room buyers know that construction over there will block their view. And so what he talked about was a future development to sell the 280 rooms, of which 160 bought them. They were trying to make sure that they understood that the land around them, between their unit and the Gulf of Mexico, could be obscured, and they wanted to state it that way. And in that beach club, they said, but if we build a club, once you know buy the unit and know that you may be looking at the north side of a condominium on the Gulf front, where you're going to get, if we build it, a free 1-year membership in the beach club, so to speak. Of course, the beach club could be there before the new development. But I'm not saying it's hanky-panky or anything wrong with it, but the obstruction of views and the reluctance to purchase because you couldn't see the Gulf was the purpose of that particular one. Another one was construction. It's in that Fourth Amendment complaint, and the construction paragraph that was written in there and was stated to be the model and was to be the one our 5 buyers bought, said that construction of a not existing building is got more guesswork, not guesswork, but problems than it does with buying a completed home. And so we want to tell you that in the process of construction, we may make changes. And the changes that we make in constructing your unit, we want to warn you about, and you need to, before you sign and give us 20% of whatever it is, you need to look into it, and it even got a paragraph that says you may want to check with your lawyer. So the point, when the judge read all those in the Fourth Amendment complaint, it was he thought, an excellent example of making all of the purchasers aware that this condominium crossing the Gulf, maybe having other development, the beach club is an addition, so to speak, and we'll if we build it, it will be, we will try to let you accommodate with it. Yes, sir.
But if all that being true, the developer was real concerned that things may change and they may not be getting what they think they're getting, obviously, or at least the allegation is, when they sat us down at the sales table, they had a hard sell on us, and they told us it's going to be this, it's going to be that, and not until we go to page 47 or 12 or whatever it is of the contract in standard print, not large print, do we find out that things may change. You know, I think what counsel's arguing is if you were truly trying to disclaim, or what the law expects of you, if you're trying to disclaim these misrepresentations or not, we assume they are at this stage of the proceeding, the law requires it to be done in a more conspicuous way than it was done. Is that, how do you respond to that?
The part of the condominium law has grown in 20 years, and has grown more with disclosure and offerings and prospectus than anything else. The prospectus, they even tell you to put on the front page, warning, well, maybe not warning, but it's the print this big, and it's the only thing on the page. Oral representations, don't count on them. Read what's behind this page, which is the prospectus. And in that connection, the prospectus is 20 paragraphs now with what you have to put in that prospectus, and it's an excellent job. And that's my answer to you, that when the legislature tells you where to put the warning on oral representations, and I'm going further and say written representations, and if we comply with that and put it in there, it is that's the best we can do unless we go overboard with it.
Was that attached to the complaint in any way? Was that, because the trial judge looked at counts 1 and 2 and he said, I'm looking at those allegations and I'm finding them to be refuted by things that are attached to the four corners, which he was allowed to do at dismissal stage. You're telling me that, you know, if you're looking for the more conspicuous disclosure, you got to look at something outside the four corners of the complaint. Doesn't that tell us that dismissal was inappropriate? Summary judgment you might get, but he shouldn't have dismissed them based upon the four corners of the complaint and things attached to it.
The four corners of the complaint contain the same oral statement. It's at the very last of it, and it was double printed, if you get what I'm trying to say, because we've learned long ago that that warnings and advice, if you call it that, things that will affect maybe or impact on your occupancy, you better look into it. And it's not a threat, but it's an advice, because construction of 200 units in one place, which amounts to 4 acres, you need some help in order to be careful.
Now, let me ask you this question. It's probably outside the scope of our view. What's going on over there with this condominium? Why are people fleeing from it? I mean, was it the economy? Was it what is your client alleged to have done that has caused this mass exodus? Or is it just the economy, that people got into a deal when the economy was good and now they want to get out of it?
2 points. One, we're still there and selling units. 160 units are left to sell. We've got people in the place at this time. We give 4th of July parties. We're still selling units. The problem is that the economy, you can't borrow 80% of the money to build buy a unit. That's outside the record, but you asked my opinion on it. But we're staying with the program in that connection. the bottom line is that most people who purchase in Panama City, Florida, and we've been over there 50 years in this business, not this kind, but motels and some law. Most of the people who are in Panama City are extremely patient, just waiting for this thing to get over with. There aren't that many litigations like this. Everybody knows the situation with money, and that's why the situation is going. We have about half the units to sell, and we're staying with it and selling them regularly. The representations here. I'm sorry. I haven't been to the District Court of Appeal in 20 years. You probably can tell that.
Counsel, was certified return receipts filed with each one of the individual plaintiffs?
Yes, sir. We do. I wanted to touch on the last subject, and that has to do with the documents, namely the amendments given to how do they get to each one of the owners. We were criticized for this somewhat by the opposing counsel, which he's free to do, but we relied heavily on a statement in the brief of the appellant at page 3, in which he stated in that brief that the developers did not send all of the documents, including the required documents, which is for the prospectus and other, until November of 2007. We relied on that statement. He had an exception in there to it, but the language that he used for that statement was for not the purchasers, which is the 5 people that are represented here today, but all of the other people involved in it. When it came time for the purchasers to take a position in his brief, he said the purchasers then filed their termination after they received their documents. You follow me? The difference between purchasers, which are the 5, and then the owners that or the other people that were involved was ahead of that. Now,
well, the fact that you didn't send them to them until November, when they were approved by the state in April, really worked in their favor, didn't it?
It did.
There's no argument. You're not making the argument that they had 25 days from when they were approved by the state.
No, I'm making the argument that they got what is required by the prospectus and by the complaint in that particular regard. I want to eliminate that issue. Now, in terms of when they canceled, that's another issue. But the complaint, the Fourth Amendment complaint, centered on one fact, and that was to terminate the contract and get their down payment back. And to do that, it was the question of material alteration coupled with proof of adversity. I looked at the one interrogatory.
Even before that, there was a time frame within which they had.
That is true. In looking at the interrogatories on a Mr. Bryan, who was also a purchaser but not here in this appeal, Mr. Bryan was a man who obviously had an ability to purchase some other property. But in connection with his answer to the interrogatories, what damages have you had, and what is your complaint about material alterations or additions? On the first one, he said my cost, my attorney's fees, and I'm out $250 at this point. He stated, nobody that I have seen stated the cases you hear all the time about budget increases, and there are a whole bunch of them in the brief for the appellant. But in the case, what we're talking about is a structural issue in which a case that I cited to you says that when it relates to construction for material alterations and an adverse effect, that means a material alteration in the structure itself as to how it was built, what was involved in it.
Well, let me ask you this
and
question.
that isn't in before you today, and not in the lawsuit.
One quick question.
What we're talking about is how...
Counsel, let me ask a question. Is the test for materiality, is it an objective test or a
Yes.
subjective? Okay.
Yes, sir. The
So
court said that.
The trial court, or have other courts?
Other courts.
Okay.
Cited in the complaint and cited in the brief of appellants.
Thank you.
I hadn't run across it for a while, but that when you're looking, if we had a condominium that a unit simply was not quality built or had problems with the furniture, and by the way, this was completely furnished for everybody in the condominium that bought, then that fits that material alteration from the plan as such. But nobody has pointed out anything but one, and that's the square footage. And if I have time, I don't know.
Counsel, your time has expired.
Oh, I'm sorry.
Thank you, counsel.
Yes, sir.
May it please the court, I guess 3 quick responses to some of the issues that just came up. One, Judge Lewis, your question about the receipts that were in the record. I'll give you the pages so you can see them. On page 830 is the Moriarty's receipt that shows it's a postal receipt, and it does show they signed for something. Page 833 is where there's a Federal Express receipt for the Rennekamp. It doesn't show they signed for something, it just says something left at door. But Dr. Hussein on page 824 of the record, all it is the receipt you get when you go to the post office to mail something certified, not the signed return receipt from Dr. Hussein. Second, in response to Judge Wetherall's question about the oral representation disclaimers, 2 quick points. One is the complaint alleges these were written misrepresentations, not oral, and the disclaimer that was, I guess, discussed during the argument is not attached to the complaint and is not part of the record. Only that one paragraph on page 12 of the contract is the only paragraph that allegedly disclaimed it that's in the record on the motion to dismiss, which is the key. And the final point is to pick up where opposing counsel started, and that is the trial court found, and I think this is correct, that we did not prove that the changes were adverse and material. But again, that's backwards. On summary judgment, it's their burden to prove the changes were not adverse or they were not material. And so the burden is on them, and using the cable TV example as a prime example, they never produced any evidence as to what this change was going to cost. And without evidence of cost, how can the trial court decide materiality as a matter of law? And that's
you agree with them the test that the trial court would use would be an objective test?
It is an objective test. There's case law on that point in Florida, I think in federal courts as well, Your Honor.
The change in regards to the cable TV was that they were going to offer a bulk services to include cable TV and the like.
Exactly.
So wouldn't that be, from a practical purpose, cheaper to the individual consumer as opposed to the individual consumer purchasing these individual services?
And I guess that's the 2 points real quick. One is they initially had a chance to opt out of that, and they lost the ability to opt out. So if you don't use cable or don't watch TV or don't own a TV, you're stuck with it. And number 2, maybe, I guess is the best answer, but the record doesn't say. And that's, I think, the real problem is there's nothing in the record to show what this was going to cost or even likely to cost. It could have been cheaper, but we don't know that in the state of the record, and that's why we think summary judgment was improper on that point and the others.
Thank you, counsel.
Thank you, Your Honor.